Good afternoon, Juanita. How are you today?
Hi, Mark. Very well. How are you?
Good. I apologise up front. I'm out in the middle of nowhere at the moment, and my signal is not very good. So Juanita will be taking over if I suddenly freeze and
Well, but we're
disappear
already
off.
struggling. You're in the middle of nowhere. I believe you're in Mitchell, which I've just learnt today where that is. So coming from downtown Mitchell.
That's right. Well, actually, it's not downtown, but and Mitchell is a nice place. Just maybe I'm in the wrong spot for the 4G signal. But no, great to be here with you again today, Juanita, talking about all things estate and succession.
Mhm.
And today, I know you'd like to kick off and talk about enduring powers of attorney to start the session off today.
Yeah, that's right. I thought we'd have a little chat about the separate document that we know is an enduring power of attorney, and because some people aren't clear exactly on what it is. So, why we have it, what you need to decide to put it in place, and a little bit about what it means and why it's such a powerful document.
Yep, I'm going to let you just
All
keep
right.
talking because nobody will hear me.
So,
And I know this won't be this will not be difficult for you, I know.
no. Oh, this is look out. I've got control here. This is going to be interesting, isn't it? Normally you
Yep.
try to shut me up. Now you're telling me to talk as much as I want. This will be good. Um, so when we do estate planning packages for clients, a lot of people obviously know about wills and that they need to put wills in place. But also another very important document is the enduring power of attorney, and this is a separate document which allows you to appoint who you would like to make decisions on your behalf if you can't make them. So the example of that situation would be if you lost capacity. So if you were in an accident, perhaps, and you weren't able to make those decisions for yourself, if you're having an operation, for example. But not only is it in a bad situation where there's ill health involved, it's also a very handy document. For example, if you were going on a holiday, on a overseas holiday, none of us have done that for a while and probably won't for a while. So get these in place now before you go. But if you were going overseas traveling, for example, you might want someone to sign documents on your behalf while you were gone, and you can authorize someone to act as your attorney to do that for you. So as well as preparing for those unfortunate situations you might find yourself in, it's also a really great document practically for those other sort of situations. Also, these days, everyone's living longer, and we find some of the elder population eventually may get memory loss or dementia, those sort of illnesses, and that sort of period of time in your life is when you might need someone to be making decisions for you. And by putting this document in place, you can put some thought into who the appropriate person is, and the right person is to do that.
Hmm.
So if I'll just keep on going,
Well, I was just going to say, if you can hear me, enduring powers of attorney. I mean, I always used to use the example of if you had a car accident and you're unable to make decisions. So it's kind of when you're not dead, but you're not capable of being able to make rational decisions. That's
yeah.
when the enduring power of attorney normally comes in. Apart from, as you say, with holidays and overseas trips, which we can forget about for a while.
And it's important also to think. A lot of people think, well, if something happens to me, my husband or my wife will make that decision for me. But what a lot of people don't think about is the next level. So if both of you, for example, were in the example you gave, Mark, in a car accident, and your spouse couldn't make that decision for you, who then would you want to be making decisions for you? And that's normally the step that requires a little bit of thought and a bit of a light bulb moment for a lot of people, that wanting to have that control of who would be making their decisions in that situation. Um, so with an
I've got a
enduring,
question for you. If
sure.
I just something came to mind. So let's just say someone has been married and they're divorced, and they haven't changed their enduring power of attorney, and they're
Mm.
now with their next partner, spouse, whatever. Uh, what's the situation there? If does the ex spouse have control of the enduring power of attorney if you forget to change it?
Yeah, this is a really interesting part of the law because there's different rules for different documents. But for enduring powers of attorney, if you have divorced someone, then the elements of the document relating to that person are basically imagine if it was just cut out with a pair of scissors, and then the backup would apply. So
Good.
you don't have the evil ex-spouse making the decisions for you. However, it would be highly recommended that, as we've spoken about before, that if you do experience a relationship breakdown and a divorce or a property settlement, that you update all these documents, because in some circumstances that is not always the case, and you could have people making decisions for you that you don't want to, or receiving things you don't want to.
Absolutely. I'm just asking for a friend.
Asking for a friend, no worries. But you can tell that friend that's the case.
Okay.
With our enduring powers of attorney, another thing to know about that a lot of people don't realise is that the document is for two separate types of matters. So you can nominate, you do nominate an attorney to make decisions about financial matters, but also separately personal and health matters. And they may be the same person, but they don't necessarily have to be. So if there's someone in your life that you think's more appropriate or better equipped to be making financial decisions on your behalf, that could be person A, but you want this person to be making decisions if you are in poor health, or about your health decisions, that could be person B. Often it is the same person. Often people will put their spouse, but perhaps in the situation where you're nominating a backup, you might have different people that you want to act for those different types of decisions.
Yeah, and that would make a whole lot of sense too, because if you've got someone from a health point of view, you'd want someone caring and compassionate, and yet the person that's best to look after your financial instruments, for example, maybe someone who's just cold and incompassionate and very clinical. So, and they would do the best job for you from a financial point of view. So yeah, it could well be. I see plenty of reasons why you would have two separate people doing that. Now, that you mentioned too before about advanced health directives, Juanita.
Yeah.
Do you want to lead into those?
Sure. I'll just add, before we leave enduring powers of attorney, I'll just add that you are able to nominate more than one person to act as well. So although, for example, I may nominate you, Mark, as my attorney, you can also nominate more than one person. So I might nominate in my 3 children, if I had 3 children, to act as my attorney, backup attorney, for example. Then you can nominate how you wish them to act. So do you wish them to act jointly? So all 3 out of 3 have to agree on a decision, or perhaps it might be a 2/3 majority. Or you can also say that they can act severally, which means any one of them can act. There's no right or wrong. It depends on the particular circumstance, and I guess you need to think about how those 3 people work together, where they're located, because if you need 3 people signing documents and one of them lives in Perth and one in Brisbane and one in Melbourne, then it might not be practical. So you need to think about where they're located, how they work together, make sure that you're comfortable that they'll make the decisions that you want them to, and what's best for that particular situation. So it's quite flexible how you can nominate your attorneys. A lot of people also will say, well, that document is just a document that I could just download off the internet. It's just a form I can fill out. And yeah, sure, that there is a template form that's prescribed by the government, by the legislation. But these days, the simple form that you can download is just insufficient for most of our clients' needs. So, for example, we would also include in our enduring powers of attorney special terms that you have the option of including. And probably a really good example of this is special terms to do with superannuation, because these days superannuation is such a large part of people's wealth, and there's a little bit of a grey area where we've seen some superannuation trustees don't want to deal with attorneys unless they've been specifically authorised to do so. So we would put in a term saying that you authorise your attorney to deal with superannuation trustees. And there's also all different little types of examples like that we would speak to a client about and understand their situation and recommend different special terms that may be suitable to be put in. So that's the reason why it's not just a tick and flick document. it's not a simple document, and it's a very powerful document. So it's really important to make sure it's done correctly and not just download it onto the printer and tick the boxes and flick it off.
This is another reason not to go to the news agency to buy the illegal document.
It is. You go to the news agency to buy your lotto, and when you win, then all your estate planning is in place. But do not go there to buy your enduring power of attorney or your will, preferably.
Okay, very, very good, very good advice.
Yeah. So advanced health directives.
Okay. Yes.
So these are separate documents again, separate to our enduring power of attorney. So as part of your estate planning package, you'll have your will document, your enduring power of attorney document, and your advanced health directive document. Now, the advanced health directive document is a document which you can specifically set out wishes with respect to particular health decisions. So things like whether you would want to be resuscitated if in a that sort of situation, whether you would want to receive life prolonging medication if you were in that situation in hospital, whether you are the sort of person who would want to get resuscitation and kept alive as long as you possibly could. If you have any specific wishes around that, then you have the ability to write them in this document or tick yes or no to a whole series of questions. So we recommend that people put this in place, particularly to help their attorneys, and probably more so, often your spouse knows about your beliefs, but if you're in the situation where you've nominated your backup attorneys acting or your children are acting, a couple of reasons why this is useful, because it puts down on paper what your wishes are. So there can be no doubt, there can be no disputes between family members, there can be no, if you're in a situation where the attorneys have to act as a majority, then it's very clear and it helps guide them with their decision as to what you wanted. But also from another level, it can take out the emotion partly for those attorneys, because these are sort of the decisions that they will have to make, and they're tough, they're emotional, and by removing the decision from your attorney and having it down on paper in your advanced health directive, it can really help them in that situation, having to make a difficult decision which might stick with them for a long time.
Yeah, I would imagine, if I can, Juanita, I would imagine that putting that pressure on children, in a lot of cases, you're right, kids would carry that guilt with themselves, even though they knew that's what mum or dad wanted. The fact that they've said turn the machine off or don't resuscitate would live with them for years and years and years. And this is a way to have a document which kind of backs up and tells the doctor, oh, these are the wishes of the person, and to take all that sort of responsibility and final decision making away from children, which could be very scarring, I would imagine.
Yeah, absolutely. As I said, they're big decisions to make, and you mentioned there the involvement of a doctor, and it's important to know with these documents. Obviously, there's some pretty heavy questions being asked, and medical terminology used throughout the document. So before the document gets signed off, you actually have to attend with your GP or with a doctor who will explain to you the terminology, make sure you understand what you're filling in, answer any questions, and then they're required to sign off a section in the Advanced Health Directive saying that they have had that consultation with you. Yep. Then after that, you're then required to have the document signed in front of a qualified witness, which is a solicitor, justice of the peace, or commissioner for declarations. And we might revert on that note back to enduring powers of attorney in a minute. But so you can see that with the Advanced Health Directive, it's essential, it's compulsory to involve the doctor in that process, which is obviously very important because of the type of questions and the types of decisions that are being made in that document.
Yeah, very good. It's but I mean, these are two things that it's easy to not do. But it can just make such a difference if they are completed when the time comes. It makes life so much easier for for those that are left behind. And I mean, this just seems to always be the common theme in everything we talk about, Juanita, is that everything we're doing is to make
Yes.
life easy for the people that are left behind, because without these things in place, I mean, it's especially enduring powers of attorney as well. If you don't have an enduring power of attorney in place, and no one can sign important documents to either sell something, keep something, move something, whatever, it just creates all sorts of grief, doesn't it, for the people that are left behind.
Yeah, it's definitely something we've spoken. I think it's come up in every single conversation we've had, Mark. That no matter what the topic, it always reverts back to making things easier for your family and your people looking after your affairs after you die. I think with the enduring powers of attorney, I was thinking as you were just talking that it's also relevant to consider if you are nominated as an attorney for someone else. So if you are an attorney for your spouse or for your parents or a sibling, it's really important, I think, to get a bit of knowledge around what your duties are, because a lot of people are nominated as their relatives or their family member's attorney, sign the document because you do have to sign the document to accept that power. So if I appoint you, Mark, I will sign it first and send it to you, and you will sign your section and give it back to me. But it's very easy for attorneys to accept their appointment without really understanding what's involved in it. There are specific duties, positive duties on an attorney. So if I appoint you, Mark, as my attorney, then I lose capacity. You are locked in and you cannot resign without trotting off to QCAT, which is the Queensland Civil and Administrative Tribunal. So it's onerous, and you have the positive duty, so you can't just sit there and choose not to do anything. That's not acceptable. And if you breach any of your duties, you can also become personally liable in certain situations. So I think there is some readily available information available for attorneys and for people making enduring powers of attorney it's a really good website. It's the QCAT website. So if you go to qcat.gov.au, if you are an attorney for anyone, I really recommend either looking at that website or speaking to your solicitor to get a fact sheet. Lots of solicitors will have fact sheets on their websites. We certainly do at Murdoch. So if you are someone's attorney, I really recommend at least getting a basic knowledge of what your duties are, so you know. Again, it's just so easy to accept without knowing what your responsibilities are if they are called in.
Okay, great advice. Thank you, Juanita. And I hope you can still hear me at this stage.
We can hear you. I saw you taking notes then. So maybe you're an attorney for someone and you've just had a light bulb moment.
No, but you were giving good advice, so I actually wrote it down. So there you go, with my special
Murdoch lawyer's pen. I know. I don't have one. I've just got the cheaper Woolies variety. I need to get my Murdoch's pen for next time.
You better speak to the guys. Hey, one of the other things we talked about. So thank you for that on advanced health directives and enduring powers of attorney. That's it's really interesting, and I hope people sort of take your advice there. Juanita, one of the other questions is, excuse me, and this was raised in conversations I had with some clients yesterday, is who can contest wills? Why and who and how can people contest wills? And once again, I mean, all the work that we do is and certainly myself, is to make sure that there's harmony between all of the kids in the relationship, so that no one's going to want to contest the will because they understand the logic behind why parents have done things in certain ways and so on. But there's always a risk, and especially for those who don't work with us, there's always a risk that children, others, and others, not just children, may try to contest a will. How can you stop, and amongst all this, if you could please answer, how do you stop a frivolous claim?
This is a great topic. I could talk about this topic for well over the 10 minutes that we've got left, but I'll try to keep it brief. Where do I start? So the first question you mentioned is who can contest a will. And hopefully I'll start this conversation by noting a lot of people will say to us, well, people can contest a will anyway, so why do I even bother with a will? So hopefully by the time I've finished giving some advice here, you'll understand why, if you didn't already appreciate, a will is still so valuable. I think we've given hours of advice over these Facebook streams already, so
Sure.
you get the gist. But first of all, not anyone can contest your will. So there's only a certain class of people that can. So this is a starting point. So the only people that can contest a will is a spouse, a child, or a dependent, essentially. Spouse can include de facto spouse, same-sex spouse. Children can include stepchildren. That's something a lot of people don't know. So if you're in a second marriage, your stepchild can contest your will. And if someone's financially dependent on you, for example, a parent or perhaps even a former spouse who's a biological parent of your child, there's also that category too. So your siblings can't contest your will, your grandparents can't, your cousins can't, your neighbours can't, etc., etc. It's only a
That's good
child,
news.
spouse, child, or dependent. Yes, a lot of people are worried their siblings might, but that's not the case. So that's who. I guess why and how. So when people make these specific types of applications, it's an application to the court, and basically they're saying that they should receive further provision from the deceased estate than they did receive. Whether they are eligible to make such an application and contest a will, which is the layman's terms, just because they're eligible doesn't mean they'll be successful. So the main reason why this ability exists in the law is to provide for people that haven't been provided for and have a need, and I guess there's a moral obligation that they should have. So for people that make such an application that are really financially comfortable and have no specific financial or medical need, probably won't get very far. Of course, depending on, unless you're the son of Kerry Packer or something like that, where you've got a huge estate. But generally, you have to prove some sort of financial or medical need that you should be provided more. Then the court looks at, if it ever gets to court, because I should say that most of these sort of applications are settled or mediated well before they get to court, which is a good thing because court is expensive. So we don't we don't encourage people to proceed to court on lightly, because it's expensive, it's stressful, it's not a fun process to go through. However, if it does get to court, and in assessing what you might achieve if you were to make an application, the court would look at things like what your financial status is, what your relationship with the person that died was, if you had a great relationship or you were estranged, if you have any dependents to support, if your spouse is doing really well or your spouse isn't earning much either, and you have to disclose all that information. What the size of the estate is, if there's other beneficiaries that were named in the will that the deceased wanted to support. So all those sort of things too. And you can see it's not a black or white decision or process. It's a lot of things that are considered in deciding if someone should receive any further provision than they already have, or if they haven't in someone's estate.
So a quick question. So let's just say there's a wealthy mum and dad. They've got 4 children, and one of the kids has given them a lot of grief, or hasn't been helpful in regard to helping them, build the estate, or they're married to someone that the parents don't like, and they think that they're just pushing for money from the estate and so on. So if there's an estate of 100% and it goes 30, 30, 30, 10, does the child that only gets 10% because he's had a falling out with mum and dad, does that give them an automatic right to challenge? I mean, they probably will, because they're angry and they feel like they've been slighted at the expense of the other kids. But does that is that in itself a reason for someone to be able to have, and I won't say to be able to contest a will, but be able to have success in contesting a will?
Well, I guess the first answer to that is they are eligible because they are a child. The fact that the will says 30, 30, 30, 10 doesn't give them automatic reason to contest. But if they can prove that all those things that I just mentioned will come into consideration, but if they can prove that they have a genuine need financially or medically, etc., or because they have to support someone, that they should receive more than 10, that's the argument that they need to put forward. But the point the example you just gave, the fact that a child may be estranged from that parent, obviously is relevant to the reason that they were left with, in your example, 10% instead of 30. So the court would consider the circumstances for that. So was the estrangement, whose fault was the estrangement? Because sometimes a child might be estranged, but it might be the doing of the parent, not the child. So what were the circumstances? What was the cause? In its entirety, what did that relationship look like? So, as I said, there's no black or white, but the child definitely could make an application to contest the will or ask for further provision. Whether they succeed or not, there's a whole lot of homework that's got to be done and evidence put forward to be successful in such an application.
You're being a lawyer, Juanita. You're not giving me an answer. So,
but can I tell you that if you make a frivolous application, then then this is not a good idea, because the court does not look lightly on people making frivolous applications and wasting people's money and time, etc. So if you are given the advice that you have a frivolous application and you're not likely to succeed if you proceeded, and you did anyway, then you expose yourself to pay for costs, even other people's costs potentially. So this is a good reason why it's a deterrent for people that think, well, I'm going to run down the estate anyway and no one will get anything. That strategy does not always work and can really expose those sort of we call them vexatious litigants. So that those sort of people that just want to.
That just sounds bad.
They just want to get, make sure no one gets anything. If I'm not going to get anything, no one will. That doesn't really cut it.
Well, because the point is that in most cases, is this not true that whoever makes a claim against the estate actually pays all the legal costs? Is that a general rule of thumb, except for vexatious litigation?
Vexatious litigants. It is
litigants.
It's not always true. So that is something that some people. It is a myth. It's often the case that may happen. Certainly, executors, if they're defending the estate against such a claim, their cost would come out of the estate. But often, in settling these matters, it may be agreed that the parties will pay their own costs. So it doesn't just automatically come out of the estate. So you shouldn't go into one of these situations thinking, I don't have to pay for anything. The estate will pay for all my costs, because it's not necessarily so. So that is why you need to get good advice, because there's lots of technicalities around this area of the law, and it's not just every child wins a prize and anyone can contest a will. It's just not true.
Yep. Okay. Look, I understand, and as much as I called you a lawyer for your answer because you didn't give a black and white answer, I also understand that the courts aren't black and white in these areas, that's probably the issue, isn't it?
That's right.
I just disappointingly see that there's a rise in the number of people who do contest wills these days, and
yes,
my take on that has been it's probably a blight on the legal industry for encouraging it and advertising to contest wills. I know there are genuine cases where people need to and should, but it seems to me that it's become more and more a case of, I might as well just see if I can get a bit more. So I'm glad you have told us all about vexatious litigants.
That's your new word for the day.
I'm going to use that word in the next couple of weeks whenever I can. So.
Just throw it in a conversation one Friday night and see if what people the look on people's faces. What are you talking about, Mark?
Well, I'm doing a presentation to a whole lot of crazies tomorrow, so I might just throw that one in there and see the reaction. I'll let you know. But look, Juanita, thanks again. Our time is up today. And thanks very much. As usual, you're a font of knowledge, and really appreciate, Juanita, the value that you bring to these conversations. And thank you.
Thanks, Mark. And I'm glad we didn't lose you. We didn't lose your connection through that half hour.
I'm still in Mitchell, and here we go. Anyway, thanks again. Look forward to catching up with everyone next week. Thanks, Juanita.
Thanks, Mark.
That's we'll see if our